welcome to Bloomberg Quint. You're watching the fine print. It took just a weekend for IL&FS and its 348 group entities from getting sucked into a litigation whirlwind to getting complete immunity from it. How did that happen? Aide Jayesh of Juris Corp and senior Bombay High Court advocate Vikram Nankani will join me in just a bit to share their views. But first, a quick wrap of what's happened so far. IL&FS was taken over by the government after it defaulted on its debt repayments multiple times and a new board was constituted. Last week, the Mumbai bench of the National Company Law Tribunal denied the government's plea to grant a moratorium to IL&FS and its 348 group entities. The government had sought a 3-month immunity for all these companies so that they are not called upon to meet any financial obligation arising from a term loan, commercial paper, fixed deposit, guarantees, etc. It had also requested the NCLT to bar continuation or initiation of any suits, arbitration or recovery proceedings against IL&FS and its group entities. The government used Section 241, 242 of the Companies Act to make this application. Section 241 allows the government to apply for an order if the affairs of a company are prejudicing public interest. And 242 lays down the powers of the tribunal when such an application is made. The NCLT dismissed the government's application, saying the relief that's sought by the government is similar to the moratorium under the Insolvency and Bankruptcy Code, or IBC, which shields any entity from any recovery or legal action once it's admitted for insolvency. But since IL&FS is a financial services provider and IBC doesn't apply to it, the moratorium cannot be granted. The Companies Act, the NCLT said, doesn't provide for any moratorium when a company is restructuring its debt, as is the case in IL&FS. Since some of the group entities are already under IBC, a blanket moratorium cannot be given. And finally, relief under Section 242 has already been granted by allowing the government to take over the board of IL&FS. In short, this whole case raises one simple question. Can the tribunal grant moratorium or relief under Companies Act when a debt restructuring is underway? Let me first bring in H. Jayesh, founding partner of Juris Corp, for his views on this. Jayesh is representing several creditors in the matter. Jayesh, welcome to the fine print. What do you make of the NCLAT decision to grant IL&FS and its group entities this interim moratorium?
So it's a well-settled principle of law that a relief which cannot be granted as a final order cannot be granted as in an interim order. Now, can you please tell me, can a moratorium ever be granted as a final relief? The answer is obviously no. You cannot have a permanent moratorium. Now, how can that then be granted as an interim order? And that's why some of the statutes explicitly provide for moratorium, because otherwise it's a well-settled principle of law that what can't be granted in a final order cannot be granted in an interim order. And again, that seems to have been forgotten by the powers that be.
Okay, so let me come to the specific provision under which this interim order has been passed, and that's Section 242, that allows the tribunal to make an order as it thinks fit if the affairs of company are being carried out in a way that is prejudicial to public interest. Jayesh, should one not read this to mean that the tribunal has wide amplitude to put an end to mismanagement of a company by passing an order as it deems fit?
Yeah, so it is 242 which empowers the tribunal to pass an order, and 242 very clearly says that with a view to bringing an end to the matters complained of, make such orders as it thinks fit. Now, while one may harp upon the wide latitude of the term such orders as it thinks fit, that is completely circumscribed by the language with a view to bringing an end the matters complained of. Now, what has been complained of? Mismanagement or operation? That is at the most what has been complained of. It is not a case that the creditors are harassing the management, etc., and therefore bring an end to those harassment. So given that the complaint before the NCLT was that the IL&FS and the group companies were being conducted, the affairs of those companies were being conducted in a manner prejudicial to public interest, now you can only pass an order which can bring an end to that. Now, that would mean change of management and things related to that, which a first step has already been taken where the board has been reconstituted. Now, of course, there's Section 244, which allows interim orders to, as it deems fit, the NCLT deems fit. But it again is circumscribed by the further language which says, for regulating the conduct of the company's affairs. Now, this has been read always to mean company's affairs qua or as in between the management and the shareholders. To read this now suddenly to mean that to regulate the company's affairs would mean, actions of creditors is really not only, I would say, unprecedented, but really, expanding the scope of the statute beyond what the parliament would have intended. And we cannot forget that, where the parliament wanted either the regulator or a forum like the NCLT or before that the CLB in the High Court to have moratorium powers, they explicitly stipulated so. And if you look at whether the Insolvency Bankruptcy Code or the earlier precedent, which was the Sikh Industrial Companies Act, and even the Banking Regulation Act, they have the words explicit of suspension of legal proceedings, etc. All of them state so. Now, the Banking Regulation Act is very interesting. You have Section 45, which basically allows the RBI to apply to the government to impose a moratorium, and if such a moratorium is imposed, suspension of legal proceedings is explicitly mentioned. But you have a separate section, which is Section 35 capital A, where RBI has explicit powers to issue directions in public interest. And those directions can be issued to all banking companies, a particular banking company, and so on. But the very fact, and directions as it deems fit, again, there is no circumscribing those powers. But the fact is, though, the ability to issue directions as it deems fits is a separate provision from that of imposing moratorium. So wherever the parliament wanted the regulator or a judicial authority to have the powers to impose moratorium, they have stated so. And let's not forget, Companies Act was amended when the Insolvency Bankruptcy Code came in for the purpose of implementing the Insolvency Bankruptcy Code. So the parliament very well knew that on one hand, for creditor-driven winding up under the Insolvency Bankruptcy Code, we are having moratorium. Now, it could be argued that since the FRDI law has not come in, otherwise you would have had similar powers. But that similar power would have been only as regards the holding company, which is IL&FS itself, and not its subsidiaries, most of which are not NBFCs. So, most of those entities which are not NBFCs, the only way they could have got a moratorium would have been then applying under the Insolvency Bankruptcy Code in respect of those companies and then taking a moratorium. But which would also mean the current management loses its ability, the directors vacate their powers and so on, and anybody can come in and submit a resolution plan. So that begs the question, why is the government avoiding powers under IBC, and why not move a petition under the Insolvency Bankruptcy Code, given that the subsidiaries of IL&FS have defaulted and they're not in the business of rendering financial services.
Sure, but the objective here seems to be to restructure the debt at the group level. And how will you achieve that if piecemeal resolution, like you're saying, through insolvency is allowed? Of course, I'm talking about companies within the IL&FS group that don't provide financial services and are hence covered by IBC.
Yeah, but actually that begs a fundamental question: whom are we really trying to protect? I mean, this is worse than robbing Peter to pay Paul, I would put it, and bluntly, if I may say so. You had creditors at the holdco level, and they did whatever diligence they did. And now you have creditors at the various subsidiary levels who gave credit on the basis of the individual assessment and not necessarily on the basis of the parent, the holding company's assessment. To protect the creditors of the holding company, you are now penalizing the creditors of the subsidiary companies, which is really unprecedented, and I don't know whether to what extent the powers that we have analyzed, the damage they're causing. We talk of ease of doing business and India's ranking on enforcement of contracts and all of that. By even moving such an application, where you're seeking a freeze on all the group companies in one go, you're telling the whole world that in India there is nothing like limited liability. There is nothing like restrictions on lifting the corporate veil. Whenever we feel like, we'll just move the forum and have the corporate veil lifted. It may well be that all these operating companies of IL&FS were part of IL&FS group, but now suddenly to say that, which is what they're implicitly saying, that all these companies were actually a single balance sheet, and therefore we need them to be treated as a single homogeneous unit, and please disregard them being distinct legal entities. That is one fundamental problem I have. The other problem is that we are talking of maximizing value, but the question is whose value? Why should the creditors of the individual companies suffer because of the creditors of the parent company did not take action in time? You already have proceedings pending against some of these subsidiaries. They are now being told that you will get shut out, you can't do anything, because we, the government, believe that the parent company needs to be protected. And I don't know whether anybody's done the study. I wouldn't be surprised if it turns out that the class of creditors at the parent company are, as a homogeneous mass, are quite distinct from the class of creditors at the operating companies. And maybe that is what is driving the government to do this. I'm just speculating here, but I would be interested in a study which dissects and aggregates, the creditors into, say, public sector banks, other banks, and NBFCs, and which of them has greater exposure at which level.
Well, we'll come to know more on this on November 13. That's where the next hearing is scheduled for. But Jayesh, the NCLAT has said that 5 of the largest creditors of IL&FS should be made party to the case. Though the line specifically doesn't say of IL&FS, they've just said 5 of the largest creditors should be made party to the case. These creditors then will get an opportunity to make their case. So what irreversible harm can this interim relief cause to them? Or do you fear that this interim relief could be extended for then a longer period of time?
So I have multiple issues with that. First of all, there's ambiguity in the sense we are assuming that they mean 5 largest creditors of each of the entity. If you're saying 5 largest creditors only of IL&FS, that only proves my point further, right? That's one. Now, let's take some of the creditors, at least certainly at the subsidiaries of IL&FS, they include mutual funds. So you're now suddenly telling a mutual fund, you cannot enforce your rights, you can't do anything. So what if you have to redeem? You have liabilities in turn to honor. So we are just not, dealing with the sanctity of contracts issue again. To protect X, we are putting hordes of others into potential and maybe even hazardous, issues where they may have to start reneging on their contracts because suddenly the money which was due to them is not only not coming, but the rights they have, including set-off rights, etc., cannot be enforced. So, which is why I have a fundamental, issue with the approach, and which is the government to start with. That when they move such an application, do they even realize what are they doing from a, the financial markets integrity perspective? You are actually stepping in to protect a set of creditors at the most. I'm not even clear that that is the intent at the parent level, at the cost of the creditors at the various operating company levels. And how? By saying that, by seeking such an order, which is now in force for 30 days, right, at least, that nothing can be done. Now, if you look at it, it's only the insolvency code which has such a grave moratorium provision. And there it is very clear that if within 180 days, either or 270 days for that matter, the company gets taken over or liquidation follows. Now that approach is not being taken. That is one aspect of it. And let's forget for the minute the division between financial services and other companies being covered by the IBC. The second aspect is well settled rights, contractual, statutory and common law rights are being suspended by the nature of the order which was sought for and which has been granted. Now, what is the benefit of this? The benefit purportedly is that the IL&FS has a better chance to recover itself. But that begs the question that what was the board of directors, the erstwhile board that is, of IL&FS doing for so long? If the water had reached well above the nose, then, what is the message you're sending to the market? Oh, if you're too big, don't worry, you can be reckless and whatnot. But we, the government, will come in and bail you out, even though it may hurt the other creditors at large, so what? That is the message we're sending out. A huge systemic risk has been created by the conduct now which is panning out before us, which is, and at the cost of repeating myself, that even if a board of a large conglomerate or a holding company doesn't behave in a pragmatic manner, it is the creditors of the
moratorium or a relief like that requested by the government cannot be granted by the tribunal under the Companies Act.
So that puts the thing in perspective. It's not the moratorium per se which people can object to, because you would have no objections if 348 subsidiaries covered by IBC were put under the hammer, and there was a moratorium which would kick in respect of those 348, which means you could not do anything for 180 plus 90 days till you had a resolution plan, or if you didn't have one, then you would send them to winding up. So it's not the moratorium per se. The question therefore is, can a moratorium be granted under section 241, 242 of the Companies Act? Now, I know that those who are purinists will say that the conventional theory must be sustained. If you don't find that expressly in an act, you cannot grant that relief. But again, the point is there something which prohibits the NCLT from passing such an order under 241, 242? Is it something repugnant to the provisions of the IBC, in which event you set up the next question as to which act prevails over the other? Now, I understand that you have run-of-the-mill cases which normally get covered under 241, that is minority being oppressed by the majority, in a few cases the majority being oppressed by the minority, but those are the run-of-mill cases. Sometimes an extraordinary situation comes up and you need an out-of-box answer to that. When the government exercised its powers under section 396 of the old Companies Act in relation to the NSCL case, eyebrows were raised. Nobody had even thought about it. People had forgotten about that section until the government exercised its powers of merging the two companies under that power. Similar is the situation, it seems here, that there needs to be a need of the hour to come out with an out-of-box solution. Now, once you find that there are words in the section itself which says prejudicial to public interest, give it a meaning and give it a full and an effective meaning. Now, if that means trying to find a solution within the wider relief, then merely because there is no express provision, I would think that that's not an answer to say you can't do it in the absence of an express bar or a prohibition not to do it.
Okay, so would that not open the door to your mind to a variety of public interest, arguments coming your way in the future? What kind of precedent then this, sort of reasoning hold, where you're giving meaning because this case is not just run-of-the-mill case?
I respect that every legal entity every corporate entity is a separate legal entity, and in very rare and exceptional cases that you should penetrate the corporate veil and extend your arm to the persons behind it. So I understand those exceptions, but it is in rare cases that this principle will have to be applied. It will have to be tested in every case as to what is a public interest. Now, given the size of the relief, the amounts involved, given the complexity of the number of diverse projects that are involved, given the number of entities that are involved, and also look at it the other way around. As I said, you would be happy, or you could do nothing about, even if you were not happy, the moratorium which would kick in under the IBC had these 348 companies gone under the IBC and the petitions were admitted. You could not crib and cry about it. Now, just because it has been housed under a different section, now you seem to think that this is something which is an exception, and it's an exception which is widely capable of being abused. Let's also look at it the other way around, that what is the success of the matters under IBC? How many companies have we really found till date good, effective, speedy resolution? If those are matters which are going to be languishing, if there are going to be interlocutory disputes and applications being made in NCLT, we have seen matters pending for a year or maybe more than a year, certainly more than 270 days in many cases. There again, the entire statutory intent is being defeated in some form or manner. Now, if that is being tolerated today, or is being, and people can do nothing about it, even if they cannot tolerate it, the point is that when you have an expression like prejudicial to public interest, and if the facts of the case so demand, just because this is an extraordinary situation, you have to then rise above and exercise those extraordinary powers.
I take your point, sir, that they would have to contend with the moratorium under insolvency, but there the creditors would have a seat on the table based on their hierarchy and a say in the what happens to the companies going forward, and some certainty or visibility of recovery of sorts. Here, their rights have been completely suspended. So could there have been a smarter way to get this moratorium that makes it less onerous for some of these creditors? One, for instance, that just extended to the holdco, which is IL&FS, and left the group entities, to be proceeded against by the creditors and make their recoveries as they deemed fit?
So these are early days. I mean, we have seen the first sign in the form of 5 largest creditors being added as directed by the NCLAT. So your first job is to arrest the landslide. Only when you can do that, then the situation is somewhat under control. You could combine these powers under other provisions of the Act, like a Section 230, which allows for a scheme, some kind of an arrangement, some kind of a compromise, and maybe all the lenders will sit on the table and will have a say, and people will decide who will take what hit and what haircut in the same manner as you would have resolved a resolution plan under the IBC. So I'm sure that this moratorium is a pro tem measure. It's not there for long to stay. It is, as I said, only to arrest the landslide, only to ensure that people don't get caught in that quicksand and somehow they are staying above, the head is above the water, and they are able to then find a solution. But if tomorrow there is nobody else and everybody sinks under, then there is going to be nobody left to find a solution. As I said, where has the IBC really led people into? How many successful resolution plans have been executed, and how many have been done so in time as per the statute? So there again, one has to weigh the pros and cons and look at the practical merits of the case and the success story of IBC. And that, I think, will also be a factor which the court can consider. And in such a situation, moratorium is only the first step.
Okay, so, assuming the worst, that this is just not a temporary solution and this carries on at the NCLAT with the arguments from both sides taking a considerable period of time. To your mind then, does the same section allow for such a moratorium to be extended on a longer basis and not just as an interim measure?
I'm sure the court, once it is seized of the matter, will call upon IL&FS, the parent, to come up with some kind of a scheme or a solution, and it will examine it, and it will test the bona fides, it will test how eager it is to resolve the problems, not only at their level but also at the level of their subsidiaries. Where are they going to get money from? How are they going to rescue the 348 subsidiaries? The wider issues will be discussed and thrashed out. No court is going to allow a moratorium to just continue hanging in the air forever. That just can't be done. It's an interim measure, it's a pro tem measure.
All right, Mr. Nankani, thank you for weighing in on what all of this could mean, for IL&FS, the 348 entities and the creditors, and the larger precedent that the Section 241 interpretation taken by the NCLAT sets for future. Thank you for joining us on the Fine Print, and thank you so much for watching.